So on behalf of the Bar Council, Punjab Haryana, with He Talks, sir, I welcome you to today's seminar on the conceptualization of PIL. I welcome our esteemed panelists and welcoming the members of the fraternity. Sincere welcome to all of you and thank you for joining us for this session today. Today's topic is on conceptualization of PIL. So I would like to welcome our chair for today, Honorable Mr. Justice Deepak Sibal. Sir has joined the profession, served as a DAG in the state, and was designated as a senior advocate by the High Court. He was later elevated to the judgeship, and he continues to be a guiding light for all the young and not so young advocates over here. Especially because I think, sir, I've noticed two things: that you have a different poise with which you conduct your court, and your passion for the law is very, very evident to all of us. So we thank you, sir, for accepting our invite for today's program. And so today's initiative with He Talks is an initiative that has been started by the Bar Council Punjab Haryana, and this aims at bringing together different stakeholders. We are able to get different stakeholders on a single forum to discuss law and the lens with which they are able to arrive at different policy decisions or different discussions that we are able to come together for. So apart from that, we are trying to create a successful space for dialogue, debate and discussion, and this has in order to considerably reduce the distance between the bar and the bench. So moving along with the program, I'll just take a minute to introduce the program to everybody as well. So if we close our eyes for a second, let's just go back to the 1970s, and India is a young democracy grappling with poverty, inequality, and access to justice is very difficult for the common man. It is just somebody who has a lot of perhaps resources that is able to, get into the difficulty of litigation, so to say. So justice for the common man seems like a distant dream. Enter the judicial activism era, and spearheaded by visionary judges such as Justice Bhagwati and Justice Krishna Iyer. They were inspired by the concept of class action suits in the American legal system, and they sought to adopt this sort of class action legal system to the Indian foray. Now, this is where PIL was born. They adapted this to India's unique socio-economic realities. This was not just a legal tool, but it is a beacon of hope. You have a chance to be a voice for the voiceless. So, just to put in perspective, from 1985 to 2019, 9,23,277 PILs have been filed. That is not a small number. This sphere of law always really inspired me when I myself was in law school. When I began my independent practice, like many lawyers, we face many challenges, building credibility, building a good clientele. It is very difficult, so to say. And I sought to take this up in my first PIL. I challenged the advertisement rules for lawyers. After that, recently I had another stint where I was able to challenge the helplines in Haryana and able to trying my best to get successful implementation of helplines for senior citizens done in Haryana. So this definitely was a challenging experience for me, and I sought to broaden my horizons and basically understand through this initiative as well. Let us all try to understand how a PIL ought to be drafted. We have stalwarts of the profession here. We have very, very diverse speakers here today. So without further ado, I would like to formally start today's session by requesting Kavalveer Kang sir. So sir has been a former senior DAG in Punjab. He has defended the state in multiple PILs. Sir has remained a standing counsel for the official liquidator and legal advisor to the Consulate General of Canada as well. So sir, he will be speaking on the background of PILs and his experiences with this branch of law. So over to you, sir.
PIL, as the name suggests, good evening everyone. It's public interest coming before litigation. So the primary essence of this litigation is that you're addressing a public issue and not personal, and that's how it has evolved since 1970s till date. In 70s, the traditional litigation was in practice, and the there was a lot of restriction with regard to locus standi of a person seeking redressal. The courts were considering that you have to be an affected party to approach the courts, and therefore it restricted the scope of larger issues in that era. And then in the 80s, the emergence of PIL further enhanced into judicial activism. The locus standi rule was relaxed by Justice Bhagwati's judgment, allowing public-spirited individuals or any NGOs to file cases for marginalized communities. And there have been many landmark judgments in this regard. Of course, I'm sure you all must have gone through a Sanara Khatun judgment in Bihar, or SP Gupta, where officially it was recognized that this locus standi scope could be expanded for a public-spirited person or an NGO. Thereafter, in 90s, the expansion of PIL took a different formation altogether. They extended into governance and human rights. The scope of PIL expanded beyond civil liberties, included environmental impacts, corruption, gender justice, governance issues. And in essence, it became a tool of holding government authorities accountable. And of course, as Jasathan said, becoming a bigger voice for the voiceless, and enable the courts to maintain checks and balances in every sphere of governance as well. In 2000 till date, despite its expansion and the scope, there have been concerns with regards to the misused invocation of PILs for public interest, not for public, then for personal interests. A lot of judgments came. Supreme Court imposed guidelines to prevent frivolous PILs. Though they still continue to remain a vital role in addressing modern challenges, but then the Supreme Court also directed all the high courts to formulate rules. And our High Court also has rules in place now that who can actually file a PIL. Volume 5, Chapter 1, everyone's aware of it. It's all in the High Court website. I revisited it again for this speech, but but it does clarify and gives some certain shape of how PIL should be initiated and who could actually file one. And so, I mean, it mandates that there has to be an affidavit of the person who's invoking the jurisdiction of the court under 226 regarding the bona fide. There is no personal motive involved. There is no personal interest involved. The credentials of the petitioner. All this to assist the court that it's actually public-spirited litigation. Then came the registry has been directed also, which we all will be facing, that the antecedent of the person invoking PIL has to be verified, and the registry has a rather authority to even reject it there and then or report it to the registrar. Other than the fact that PIL also can be filed by post, but not by all. It can be filed by people in jail, maybe habeas corpus petitions, seeking writ of in causes of nature that may require suo motu action. You could write to the Registrar General or to the Legal Aid Authority, and then that could be taken up to a higher level, and maybe court takes cognizance of that. And of course, courts always suo motu take cognizance of issues, and there have been so many PILs initiated by the court here itself. And so the essence remains, and I think as a lawyer, the burden of accepting a brief for a PIL is much higher for all of us than any other case. Because then you're not just espousing one person's own viewpoint, you're actually addressing a larger concern. And if your conscience believes that concern, that issue is there in the case you're accepting, go for it. The court will come to your rescue, I'm pretty sure. As long as you have faith in the cause you're fighting, the PIL, this entire mechanism is in place only for that. And in my own experience, I've addressed I've represented some PILs. We challenged the vagaries of Rent Act, where the Punjab government suddenly decided it's going to be decided by tehsildars and not the courts. And the Bar Council asked us to file a petition right away, and the court came to our rescue. And rather, the entire act was amended by the intervention of the court. So such things could only happen if we have PILs as a mechanism. And then on the defense side, we represented a very famous singer in the Honorable High Court and Division Bench, and where the petition was filed that his songs are vulgar. And I remember Justice Kaul saying, then don't hear them. So there has to be balance and a sense of responsibility of what we are espousing. And I've seen many cases as an officer when I was assisting the Honorable Court that many a times PILs are filed when you actually have a remedy in place, where you actually have a statutory safeguard in place and you never invoke that and you go straight for a PIL and courts come down heavily on that. So be be very careful what you're seeking and whether you have actually availed your remedy in law, approached the authorities, been heard or not heard, and then go for it. And with this, I thank you very much for your time.
So thank you, sir. Now I would like to introduce our second speaker for today, Shekhar Verma, sir. Sir is presently the double AG in Punjab, and I first met sir when we were jointly engaged in a matter in company law. And I must say, sir, it has been a pleasure to assist you. Your aggression and passion for the law has always been a joy to witness. And apart from that, sir's topic for today is on the misuse and abuse of PIL, and emphasizing on the need for responsible litigation.
Since I have been assigned this small topic of misuse of PIL, I must start with the statement that to understand this concept of misuse, we must first understand this is an exception to the rule of locus standi. When we say locus standi, I mean to say locus standi has to be established by you when you are filing a case. You must have an interest in your case. But when you are filing a PIL, you may or you may not have any interest in that PIL, but you are espousing the cause of a person who is unable to access justice. So it's a potent weapon. It actually helps to address socio-economic issues in a much larger way. So these two things we should keep in mind while we are filing PIL. And if I have to say what is the misuse, I'll just read one of the prayers without naming anybody. One of the prayers in the recent case decided by the Honorable Chief Justice. Just see what kind of prayer has been made, and then I'll come to misuse. I must read, sir. I just read one prayer. Direction of the celebration of festival of Karwa Chauth by women folk irrespective of their status of being widows, separated, divorces, and the women in live-in relations. What is this prayer? Somebody should have applied his mind. We all know what is Karwa Chauth. See, by filing these kinds of cases, what we do, you just affix stamp of ₹50. You sit at your home. The moment you file a case, it is checked by the registry. Objections raised, objections removed. Then it goes to the Honorable Judge. Honorable Judge reads the file, spends some time. Next day, he has to hear the case. Comment counsel like me or Amit ji, they also read these files. So everybody is spending time on these kinds of prayers. Judicial time, we hardly have any judicial time. The Honorable Supreme Court has now gone to the extent of appointing ad hoc judges. We can avoid all this. We should understand the responsibility. This kind of petition is not even maintainable, but somebody has filed it. So I would say the Honorable Chief Justice was very gracious. He has not imposed cost, just a token cost of 1,000. So this is a classic case of misuse of PIL. We should all avoid this. Now the second example I wish to give is of a case, one of us sitting here only, a very upcoming good lawyer, as I watch her in court proceedings, but I must share my experience. There was a cricket match scheduled on 9th of April last year. And I'm not getting personal with anybody, but see the kind of seriousness was attached to this case. A cricket match was scheduled in new stadium, Mullapur Cricket Stadium. The lawyer, very good lawyer I would say, they filed a case that cricket stadium has been illegally constructed. Why? Because while construction was sanctioned, there was a condition that you will have to take a prior permission from environment authorities, because allegedly the cricket stadium is situated within 10-kilometer radius of a bird sanctuary. That notification did exist, but it was subsequently modified. From 10 kilometers, it was modified to 80 meters. The moment advance copy was received, we were all in a shock. I represented that Punjab Cricket Association. We were all in a shock. We have to leave all our work because Australian cricket team was scheduled to play that match in that very next week. They could have refused to play that. It's an international match. So what we did nothing. We had just checked the website. In the website, it was clearly mentioned. It's not 10 kilometers. It's just 80 meters. So we had to just place it on record. The matter was withdrawn by the council graciously again. But see the kind of level, kind of seriousness involved in this case. The match could have been recalled. Team could have refused to play. I'm sorry. So we should be very careful. As young lawyers, we also committed mistakes. Yes, we did commit mistakes. But the concept of PL is completely different. It carries a higher responsibility. higher responsibility than a normal case, because we are espousing a cause of a person who is unable to have access to justice. So all I would request is, please don't prepare a PIL unless you are fully prepared. If we are not prepared as young lawyers, we can take assistance from persons like Mr. S. C. Arora ji or any other senior counsel. At least we should be prepared with our case thoroughly. Only then we should attempt this. It's a much more serious matter. Let us not waste judicial time. Let us not waste our resources. We have limited resources. So only request would be, please don't waste resources. We should be prepared fully, thoroughly to file these kinds of PILs. That's all.
Thank you, sir. Thank you for your valuable insights. Next, we have with us Senior Advocate Amir Jhanji, sir. Sir was designated as a Senior Advocate in 2021, and he is presently the Senior Standing Counsel for Chandigarh. Polite yet firm in his approach, and he's, like I said, a constant inspiration for young lawyers like myself. Sir has graciously agreed to speak on the topic how he would construct a PIL from just a nascent idea stage to transforming it into a litigation. So over to you, sir.
Good evening, everyone, and thank you for giving me this opportunity to speak on this occasion. Well, I feel that public interest litigation is a litigation for protection of interests of public at large. And the anchor of a public interest litigation is the identification of an issue which would affect the public at large. So that is where the nascent stage starts where you create a public interest litigation. So once you identify an issue, I would in fact take it into three key objectives. One would be an issue, and then how you take that issue into writing is what you call a drafting. And once you start drafting it, how you present to the court is the presentation of that issue and what you write in a drafting. So three components which are very primarily important for a drafting of a PIL. So once we come back to now the issue, once you identify an issue, you have to understand that the issue should be based not on personal injury, not on personal objectives, but objective which touch public at large. That is the first and foremost issue which you need to first touch. Once you have that identification of the issue, you have the Right to Information Act, where is a statute which has been created. For that, you can apply under the RTI. You have to research on the government policies. You have to understand what are the scientific issues on the basis of which that you want to draft a public interest litigation. Once you have media reports, once you collate all the data, you have to put it in writing. Now the question would be that that data may constitute 10,000 pages or 20,000 pages. So the art of drafting would come down to, once you have those 10,000 pages drafted into 50 pages. So you cannot make it into an essay or a thesis. The moment you do that, I bet your petition is going to be dismissed at the threshold because you're going to lose the judge there and then. I hope, if I'm not wrong. So once you have that into 50 pages, you need to understand to write it crisp and precise. The prayer has to be to the topic. If that is an issue which is touching environment, then the prayer has to be either seeking mandamus. If there is an encroachment, if there is an action which is to be done, then you have to seek certiorari, quashing that action of that state. So that is how you need to put it into writing. Now comes the second and the third stage is the part of presentation. How do you present it? When you file a petition, you have to understand that when you are appearing before the judge, you have to be prepared in all the aspects. You need to emotionally detach yourself from the topic. It has to be totally based on law. You cannot start arguing on an emotional aspect just to try to touch the emotion of a judge. That will never happen. So you need to understand that. So the presentation is the most important part. So there are some times when the court also says that why should we interfere in a government policies? So there are government policies which are under challenge in a public interest litigation. So the answer to that, and that is what I would submit, would be that the government policies can also be challenged. The challenge to those government policies are based on arbitrariness, irrationality, also legislative competence, also on the ground that they are violative of the Constitution. So it's not that you don't have a recourse to a remedy. There is always a remedy available under the public interest litigation. It's an identification of a problem. But the PIL also means that you have to find a solution to a problem rather than trying to sensationalize the issue. So that is what I would say. I was given a very small topic to state, but that's all I have for you, and thank you.
Thank you, sir. Next, we have with us H.C. Arora, sir. Well, sir, many of you may not know, but sir initially started as a banker, and he made the jump from banking to law in 1993. So at present, like all of us know, he is synonymous with PIL in our High Court, and he has filed over 400 PILs, like I'm told. He is also, I cannot imagine, sir, honestly, today's session without you and your insights. And I request you to share all your experiences with us, your experiences as a PIL lawyer.
The topic given to me was impact of PIL. Now you have asked me to share my experiences. So these are one and the same topic, though I have to slash some part of my drafting for the purpose of changing the topic.
Go ahead.
You can go ahead, because all four of you will leave nothing for me to say. Go ahead.
All right, then I will switch over to my mother tongue. ਪਾਲਿਸੀ ਦੀ ਗੱਲ ਹੋਈ ਹੈ ਕਿ ਪਾਲਿਸੀ ਬਣਾਈ ਗਈ ਹੈ ਹਾਈ ਕੋਰਟਾਂ ਦੇ ਵਿੱਚ, ਸੁਪਰੀਮ ਕੋਰਟ ਦੇ ਵਿੱਚ ਵੀ ਪਾਲਿਸੀ ਗਾਈਡਲਾਈਨਸ ਆਰ PIL। ਮੈਂ ਦਾਅਵੇ ਨਾਲ ਕਹਿ ਸਕਦਾ, ਔਰ ਤੁਸੀਂ ਸਕਰੂਟਨਾਈਜ਼ ਕਰਕੇ ਦੇਖ ਸਕਦੇ ਹੋ, ਸ਼ਾਇਦ 100 ਚੋਂ ਇੱਕ PIL ਹੁੰਦੀ ਹੋਵੇ ਜਿਹੜੀ ਉਹਨਾਂ ਗਾਈਡਲਾਈਨਸ ਦੇ ਵਿੱਚ ਫਾਲ ਕਰਦੇ, ਬਾਕੀ ਸਾਰੀਆਂ ਵਾਈਟਲ ਪਬਲਿਕ ਇੰਪੋਰਟੈਂਸ ਦੀਆਂ ਹੁੰਦੀਆਂ। ਸੋ ਗਾਈਡਲਾਈਨ ਜਿਹੜੀਆਂ ਬਣਾਈਆਂ, ਜਿਨ੍ਹਾਂ ਲੋਕਾਂ ਵਾਸਤੇ ਬਣਾਈਆਂ, ਉਹ ਹੁਣ PIL ਦੇ ਥਰੂ ਨਹੀਂ ਆਉਂਦੇ, ਉਹ ਕਾਫੀ ਸਾਈਨ ਹੋ ਚੁੱਕੇ ਹਨ, ਉਹਨਾਂ ਨੂੰ ਲੀਡਰਸ਼ਿਪ ਮਿਲ ਚੁੱਕੀ ਹੈ। ਇੰਪੈਕਟ ਦੀ ਗੱਲ ਚੱਲੀ, ਇੰਪੈਕਟ ਜਿਸ ਤਰ੍ਹਾਂ ਤੁਸੀਂ ਦੱਸਿਆ ਰੈਂਟ ਐਕਟ ਅਮੈਂਡ ਹੋਇਆ, ਇਸ ਤਰ੍ਹਾਂ ਬਹੁਤ ਸਾਰੇ ਇੰਪੈਕਟ ਹੋਏ ਨੇ ਸਾਰੇ ਹਿੰਦੁਸਤਾਨ ਦੇ ਵਿੱਚ, ਪਰ ਮੈਂ ਥੋੜ੍ਹੇ ਜਿਹੇ ਪ੍ਰਭਾਵ ਪੈਣ ਜਿਹੜੀ PIL ਦੇ ਸਾਡੇ ਏਰੀਏ ਦੇ ਵਿੱਚ, ਉਹਦੇ ਬਾਰੇ ਗੱਲ ਕਰਾਂਗਾ। ਐਸਿਡ ਅਟੈਕ ਵਿਕਟਮ ਬਾਰੇ ਤੁਸੀਂ ਸੁਣਿਆ ਹੋਣਾ। ਐਸਿਡ ਅਟੈਕ ਅਕਸਰ ਹੁੰਦੇ ਨੇ ਲੇਡੀਜ਼ ਦੇ ਉੱਪਰ, ਆਮ ਤੌਰ 'ਤੇ ਉਹਨਾਂ ਦਾ ਚਿਹਰਾ ਵਗੈਰਾ ਝੁਲਸ ਜਾਂਦਾ ਹੈ, ਕਿਉਂਕਿ ਚਿਹਰੇ ਦੇ ਉੱਤੇ ਅਟੈਕ ਕੀਤਾ ਜਾਂਦਾ ਹੈ ਐਸਿਡ ਅਟੈਕ ਨਾਲ। ਸਾਰੇ ਹਿੰਦੁਸਤਾਨ ਵਿੱਚ ਪਾਲਿਸੀਆਂ ਨੇ, ਸੁਪਰੀਮ ਕੋਰਟ ਨੇ ਪਾਲਿਸੀ ਬਣਾਈ ਸੀ, ਡਾਇਰੈਕਸ਼ਨਾਂ ਦਿੱਤੀਆਂ ਸੀ, 3 ਲੱਖ ਰੁਪਏ ਤੱਕ ਕੰਪਨਸੇਸ਼ਨ ਪਲੱਸ ਫ੍ਰੀ ਹੌਸਪੀਟਲਾਈਜੇਸ਼ਨ, ਫ੍ਰੀ ਟ੍ਰੀਟਮੈਂਟ। ਪਰ ਸਾਡੇ ਹਾਈ ਕੋਰਟ ਦੇ ਵਿੱਚ ਮੈਨੂੰ ਇਹ ਮਾਣ ਮਿਲਿਆ ਕਿ ਇੱਥੇ ਜਿਹੜੀ ਅਸੀਂ PIL ਪਾਈ ਸੀ, ਉਸ ਦੇ ਵਿੱਚ ਜਿਹਨਾਂ ਲੇਡੀਜ਼ ਦਾ ਚਿਹਰਾ ਝੁਲਸ ਜਾਂਦਾ, ਅਤੇ ਹੁਣ ਮਰਦਾਂ ਦਾ ਵੀ, ਉਹ ਮਰਦਾਂ ਨੂੰ ਵੀ ਇਕੁਐਲਿਟੀ ਦੇ ਦਿੱਤੀ ਗਈ ਇਸ ਇਸ਼ੂ 'ਤੇ। ਉਹਨਾਂ ਨੂੰ 8000 ਰੁਪਏ ਸਾਲਾਨਾ ਸਾਰੀ ਉਮਰ ਵਾਸਤੇ ਪੈਨਸ਼ਨ ਮਿਲਦੀ। ਗੱਲ ਚੱਲਦੀ ਹੈ ਪਾਲਿਸੀ ਦੀ। ਕਿਹਾ ਜਾਂਦਾ ਕਿ ਪਾਲਿਸੀ ਦੇ ਵਿੱਚ ਕੋਰਟਾਂ ਜਿਹੜੀਆਂ ਦਖਲ ਨਹੀਂ ਦੇ ਸਕਦੀਆਂ, ਪਰ ਮੇਰਾ ਐਕਸਪੀਰੀਅੰਸ, ਜਦੋਂ ਤੁਸੀਂ ਗੱਲ ਕੀਤੀ ਤਾਂ ਹੁਣ ਮੈਂ ਥੋੜ੍ਹਾ ਜਿਹਾ ਭਾਵਨਾਵਾਂ 'ਚ ਬਹਿ ਚੁੱਕਾ। ਗੱਲ ਚੱਲੀ, ਪਟੀਸ਼ਨ ਮੈਂ ਪਾਈ ਸੀ, ਜਦੋਂ ਮੈਂ ਬਹਿਸ ਸ਼ੁਰੂ ਕੀਤੀ ਕਿ ਜੋ RTI ਐਕਟਿਵਿਸਟ ਹੈ, ਉਹਨਾਂ ਦਿਨਾਂ ਵਿੱਚ ਜਦੋਂ RTI ਐਕਟ ਸ਼ੁਰੂ ਹੋਇਆ ਸੀ, ਐਕਟਿਵਿਸਟ ਵੀ ਬਹੁਤ ਜ਼ਿਆਦਾ ਐਕਟਿਵ ਸੀ, ਉਹਨਾਂ 'ਤੇ ਅਟੈਕ ਵੀ ਬਹੁਤ ਹੋ ਰਿਹਾ ਸੀ, ਕਈ ਮਾਰੇ ਵੀ ਗਏ ਸੀ। ਚੀਫ ਜਸਟਿਸ ਸ਼੍ਰੀ ਵਿਜੇਂਦਰ ਜੈਨ ਜੀ ਸੀਗੇ, ਉਹਨਾਂ ਨੇ ਜੋ ਆਰਡਰ ਲਿਖਾਇਆ, ਉੱਥੋਂ ਅੰਦਾਜ਼ਾ ਲਾ ਲਓ ਕਿ ਤੁਸੀਂ ਪਾਲਿਸੀ ਵਿੱਚ ਦਖਲ ਕੋਰਟ ਦੇ ਸਕਦੀ ਕਿ ਨਹੀਂ ਦੇ ਸਕਦੀ, ਉਹ ਜੋ ਦੇਣਾ ਚਾਹਵੇ ਔਰ ਰੀਅਲੀ ਪਬਲਿਕ ਇੰਟਰਸਟ ਦਾ ਮਸਲਾ ਹੋਵੇ ਤਾਂ ਕੋਰਟ ਦਖਲ ਦੇਣ ਦਾ ਆਪਣੇ ਆਪ ਤਰੀਕਾ ਕਰਦੇ। ਉਹਨਾਂ ਦੇ ਨੋਟਸ ਆਫ ਮੋਸ਼ਨ 'ਚ ਕੁਛ ਇਸ ਤਰ੍ਹਾਂ ਲਿਖਿਆ ਹੋਇਆ ਸੀ, Admittedly, this court cannot interfere in policy matters and cannot dictate the government to frame policy. But the RTI activists, they are playing a very vital role in the democracy, hence notes of motion. And ultimately policy बनी, और इतनी शानदार पॉलिसी बनी सी कि मैं एक एग्जांपल देके दस सकदा। सलेश गांधी सेंट्रल इन्फॉर्मेशन कमिश्नर सी, सब तो पहले जो बने सी, उन्होंने मैंने बधाई भेजी सी, हैड्स ऑफ टू यू, ईमेल की सी, बड़ी शानदार पॉलिसी बनी। वो भी जो पॉलिसी बनाने का स्टेज आ गई सी कि डिसीजन देना सी जज साहब ने, उदों नवे चीफ जस्टिस आ गए, उन्होंने भी आंदे क्या ये पॉलिसी बनाने लिए डायरैक्शन किवें दे सकते, तो पंजाब वाला जो स्टेट काउंसिल से खड़ा है, लड़छिप असीं बना ली पॉलिसी। सो पॉलिसियाँ इस तरह बन जांदियां ने जो चंगियां पॉलिसियां बनानियां होण। एसिड अटैक की गल हो गई, ਹੁਣ ਮੈਂ ਆਵਾਂ ਕਰਪਸ਼ਨ ਦੇ ਇਸ਼ੂ 'ਤੇ। ਆਨਰੇਬਲ ਜਸਟਿਸ ਅਮਰਦੱਤ ਜੀ ਵਿਜੀਲੈਂਸ ਕਮਿਸ਼ਨਰ ਬਣੇ ਸੀ ਪੰਜਾਬ 'ਤੇ, ਉਹਨਾਂ ਦਾ ਵਿਜੀਲੈਂਸ ਕਮਿਸ਼ਨ ਬਣਾਇਆ ਗਿਆ ਸੀ, ਬਾਅਦ ਵਿੱਚ ਉਹ ਡਿਸਬੈਂਡ ਕਰ ਦਿੱਤਾ ਗਿਆ। ਉਹਨਾਂ ਨੇ ਇਨਫੋਰਮੇਸ਼ਨ ਮੰਗੀ ਸਾਰੇ ਮਹਿਕਮਿਆਂ ਕੋਲੋਂ ਕਿ ਜਿੰਨੇ ਵੀ ਕਰਪਸ਼ਨ ਵਿੱਚ ਕਨਵਿਕਟਡ ਮੁਲਾਜ਼ਮ ਨੇ ਉਹਨਾਂ ਸਾਰਿਆਂ ਦੀ ਸਾਨੂੰ ਲਿਸਟ ਦਿੱਤੀ ਜਾਵੇ। ਉਹਨਾਂ ਕੋਲ ਤਕਰੀਬਨ 550 ਮੁਲਾਜ਼ਮਾਂ ਦੀ ਲਿਸਟ ਆਈ। ਕਮਿਸ਼ਨ ਡਿਸਬੈਂਡ ਹੋ ਗਿਆ, ਪਰ ਆਰਟੀਆਈ ਦੇ ਵਿੱਚ ਮੈਂ ਉਹ ਸਾਰੀ ਲਿਸਟ ਲੈ ਲਈ। ਆਰਟੀਆਈ ਐਪਲੀਕੇਸ਼ਨ ਲਗਾ ਕੇ ਉਸ ਤੋਂ ਬਾਅਦ ਤਕਰੀਬਨ 650 ਬੰਦੇ ਪੰਜਾਬ ਦੇ 550 100 150 ਹਰਿਆਣਾ ਦੇ ਸਾਰੇ ਨੌਕਰੀਆਂ ਤੋਂ ਬਰਖਾਸਤ ਹੋਏ। ਕੋਰਟ ਨੇ ਵੀ ਬਹੁਤ ਸਾਡੇ ਜਿਹੜਾ ਐਕਟਿਵਿਜ਼ਮ ਸੀ ਉਸ ਨੂੰ ਪੈਟਰਨਾਈਜ਼ ਕੀਤਾ, ਕਿਉਂਕਿ ਸਵਾਲ ਸੀ ਕਿ ਪੰਜਾਬ ਦੇ ਵਿੱਚ ਕੀ ਹੋ ਰਿਹਾ ਸੀ ਕਿ ਜਿੰਨੇ ਕਨਵਿਕਸ਼ਨ ਹੋਈਆਂ ਸੀ, ਕਨਵਿਕਟ ਹੋਏ ਸੀ ਕਰਪਸ਼ਨ ਦੇ ਦੋਸ਼ਾਂ ਦੇ ਵਿੱਚ ਵੀ, ਉਹ ਵੀ ਜ਼ਮਾਨਤਾਂ ਲੈ ਕੇ ਨੌਕਰੀਆਂ ਕਰੀ ਜਾ ਰਹੇ ਸੀ। ਹਾਲਾਂਕਿ ਕੋਈ ਸਰਕਾਰੀ ਮੁਲਾਜ਼ਮ ਨੋਰਮਲੀ ਮੇਰੇ ਹਿਸਾਬ ਨਾਲ ਕਨਵਿਕਟ ਹੋ ਜਾਏ ਕਰਪਸ਼ਨ ਦੇ ਦੋਸ਼ਾਂ 'ਤੇ ਉਹਨੂੰ ਕੋਈ ਸਰਵਿਸ 'ਤੇ ਨਹੀਂ ਰੱਖਦਾ। ਲੋਕ ਮੇਰੇ ਕੋਲ ਆਉਣੇ ਸ਼ੁਰੂ ਹੋ ਗਏ, ਵੱਡੀਆਂ ਵੱਡੀਆਂ ਇਨਫੋਰਮੇਸ਼ਨਾਂ ਲੈ ਕੇ ਆਉਣ ਲੱਗ ਗਏ ਕਿ ਆਹ ਵੀ ਸਾਡੇ ਵੀ ਕਨਵਿਕਟਡ ਹੈ, ਜਾਂਦਾ ਲਿਸਟ ਵਿੱਚ ਨਾਮ ਹੀ ਹੈ ਨਹੀਂ। ਸੁਪਰਿੰਟੈਂਡਿੰਗ ਇੰਜੀਨੀਅਰ ਕਨਵਿਕਟਡ, ਲਿਸਟ ਵਿੱਚ ਨਾਂ ਹੈ ਨਹੀਂ, ਉਹ ਸਾਰੇ ਰਿਮੂਵ ਹੋਏ। ਸੋ ਇੰਪੈਕਟ PIL ਦਾ, ਜੇ PIL ਕਿਸੇ ਦੇ ਰੀਅਲੀ ਪਬਲਿਕ ਇੰਟਰਸਟ ਵਾਸਤੇ ਲਗਾਈ ਜਾਵੇ ਤਾਂ ਇੰਪੈਕਟ ਜਿਸ ਤਰ੍ਹਾਂ ਨਿਊਜ਼ 18 ਦੇ ਉੱਤੇ ਪ੍ਰੋਗਰਾਮ ਆਉਂਦਾ 9 ਵਜੇ, ਫਰਕ ਤਾਂ ਪੈਂਦਾ। ਸੋ ਮੈਂ ਇਹੀ ਕਹਿਣਾ ਚਾਹਾਂਗਾ ਕਿ ਫਰਕ ਤਾਂ ਪੈਂਦਾ, ਇੰਪੈਕਟ ਪੈਂਦਾ। ਪ੍ਰਕਾਸ਼ ਸਿੰਘ ਜੀ DGP ਸੀ ਉੱਤਰ ਪ੍ਰਦੇਸ਼ ਵਿੱਚ, ਉਹਨਾਂ ਦੀ ਪਟੀਸ਼ਨ ਦੇ ਵਿੱਚ ਪੁਲਿਸ ਕੰਪਲੇਂਟ ਅਥਾਰਟੀਆਂ ਬਣਾਉਣ ਵਾਸਤੇ ਡਾਇਰੈਕਸ਼ਨਾਂ ਕੀਤੀਆਂ ਸੁਪਰੀਮ ਕੋਰਟ ਨੇ। ਪੰਜਾਬ ਤੇ ਹਰਿਆਣਾ ਵਿੱਚ ਉਸ ਨੂੰ ਅਸੀਂ ਅੱਗੇ ਵਧਾਇਆ। ਇੱਥੇ ਡਿਵੀਜ਼ਨਲ ਲੈਵਲ 'ਤੇ ਵੀ ਜੋ ਪੁਲਿਸ ਕੰਪਲੇਂਟ ਅਥਾਰਟੀਆਂ ਬਣ ਚੁੱਕੀਆਂ ਨੇ ਪੰਜਾਬ ਤੇ ਹਰਿਆਣਾ 'ਚ, ਜਿਹੜੇ ਕਿ ਪੁਲਿਸ ਅਫਸਰਾਂ ਦੀ ਜਾਤੀਆਂ ਦੇ ਵਿਰੁੱਧ, ਉਹਨਾਂ ਦੇ ਮਾੜੇ ਕੰਮਾਂ ਦੇ ਵਿਰੁੱਧ ਕੰਪਲੇਂਟਸ ਵਗੈਰਾ ਦੇ ਫੈਸਲੇ ਕਰਦੇ। ਇੱਕ IAS ਅਫੀਸਰ ਸੀ ਪੰਜਾਬ ਦੇ, ਉਹਨੇ ਤਕਰੀਬਨ 2.5-3 ਕਰੋੜ ਰੁਪਇਆ ਆਰਬੀਟ੍ਰੇਸ਼ਨ ਫੀ ਇਕੱਠੀ ਕਰ ਲਈ। ਡਿਵੀਜ਼ਨਲ ਕਮਿਸ਼ਨ ਹੁੰਦਾ ਹੈ, ਆਰਬੀਟ੍ਰੇਸ਼ਨ ਦੇ ਅਪੀਲਾਂ ਦੇ ਫੀਸ ਉਹਨਾਂ ਨੇ ਖੁਦ ਹੀ ਤੈਅ ਕਰਤੀ ਔਰ ਲੈ ਰਹੇ ਸੀ। ਉਹ ਪਟੀਸ਼ਨ ਪਾਈ ਤਾਂ ਉਸ ਪਟੀਸ਼ਨ ਵਿੱਚ ਸੰਜੇ ਕਿਸ਼ਨ ਕੌਲ ਜੀ ਚੀਫ ਜਸਟਿਸ ਸੀਗੇ, ਉਹਨਾਂ ਨੇ ਜਜਮੈਂਟ ਦਿੱਤੀ ਔਰ ਅਲਟੀਮੇਟਲੀ ਉਹਨਾਂ ਤੋਂ ਵਿਦ ਇੰਟਰਸਟ 4 ਕਰੋੜ ਰੁਪਇਆ ਰਿਕਵਰ ਹੋਇਆ। ਨਹੀਂ ਤਾਂ IAS ਅਫੀਸਰਾਂ ਨੇ ਤਾਂ ਇੱਕ ਰਸਤਾ ਬਣ ਜਾਣਾ ਸੀ ਨਵਾਂ ਆਰਬੀਟ੍ਰੇਸ਼ਨ ਦੀਆਂ ਫੀਸਾਂ ਲੈਣ ਵਾਸਤੇ। CAG ਦੀ ਰਿਪੋਰਟ ਪੜ੍ਹੀ ਮੈਂ ਕਿ ਪੰਜਾਬ ਦੇ ਕਈ ਸਾਰੇ ਸਕੂਲਾਂ ਦੇ ਵਿੱਚ ਕਲਾਸਰੂਮ ਅਨਸੇਫ ਨੇ, ਬੈਂਚ ਨਹੀਂ ਹੈਗੇ, ਜ਼ਮੀਨ 'ਤੇ ਬੈਠੀਆਂ ਲੜਕੀਆਂ, ਛੋਟੇ ਬੱਚੇ, ਔਰ ਟੋਇਲਟ ਸੈਪਰੇਟ ਲੇਡੀਜ਼ ਗਰਲ ਸਟੂਡੈਂਟਸ ਵਾਸਤੇ ਨਹੀਂ। ਉਹ ਵੀ ਮੈਂ ਪਟੀਸ਼ਨਾਂ ਪਾ ਕੇ ਇੱਕ ਐਸੀ ਮੁਹਿੰਮ ਚੱਲੀ। ਪਹਿਲੇ ਤਾਂ ਪਟੀਸ਼ਨ 'ਤੇ ਨੋਟਿਸ ਆਫ ਮੋਸ਼ਨ ਹੋਣ ਤੋਂ ਬਾਅਦ ਉਹਦਾ ਐਂਬਿਟ ਵਿਸਥਾਰ ਹੁੰਦਾ ਗਿਆ ਔਰ ਅਲਟੀਮੇਟਲੀ ਪੰਜਾਬ ਦੇ ਸੈਂਕੜੇ ਸਕੂਲਾਂ ਦੇ ਵਿੱਚ ਅਨਸੇਫ ਕਲਾਸਰੂਮ ਡਿਮੋਲਿਸ਼ ਕੀਤੇ ਗਏ, ਨਵੇਂ ਬਣਾਏ ਗਏ, ਨਵੀਆਂ ਟੋਇਲਟ ਬਣਾਈਆਂ ਗਈਆਂ ਔਰ ਸੈਂਟਰਲ ਗੌਰਮੈਂਟ ਨੇ ਵੀ ਕਾਫੀ ਕੋਆਪਰੇਟ ਕੀਤਾ, ਕਾਫੀ ਫੰਡ ਵਗੈਰਾ ਦਿੱਤੇ। ਸੋ ਪੰਜਾਬ ਦੇ ਸਕੂਲਾਂ ਦੀ ਨੁਹਾਰ ਬਦਲ ਗਈ PIL ਦੇ ਨਾਲ। ਇੱਕ ਪੁਲਿਸ ਅਫੀਸਰ ਮੇਰੇ ਕੋਲ ਆਇਆ, ਕਹਿੰਦਾ PIL ਨਹੀਂ ਲਗਾ ਰਹੇ, ਸਾਡੇ ਵਾਸਤੇ ਲਗਾ ਦਿਓ। ਮੈਂ ਹੈਰਾਨ ਸੀ ਕਿ ਪੁਲਿਸ ਵਾਲਿਆਂ ਨੂੰ ਵੀ PIL ਦੀ ਜ਼ਰੂਰਤ। ਉਹ ਕਹਿਣ ਲੱਗਾ ਕਿ ਸਾਡੇ ਥਾਣਿਆਂ ਦੇ ਵਿੱਚ ਲੇਡੀਜ਼ ਟੋਇਲਟ ਸੈਪਰੇਟ ਨਹੀਂ ਹੈਗੀ। ਸਾਡੇ ਜਦੋਂ ਕੋਈ ਜੈਂਟਸ ਆਉਂਦਾ ਉਹਨੂੰ ਕੰਪਨੀ ਕਰਨ ਵਾਸਤੇ DSP ਲੇਡੀ ਹੋਵੇ, ਬੜੀ ਐਮਰੈਸਮੈਂਟ ਹੁੰਦੀ ਹੈ। ਮੈਂ ਬੜਾ ਜਨੂਨੀ ਬੰਦਾ, ਅਗਲੇ ਦਿਨ ਪਟੀਸ਼ਨ ਪਾ ਦਿੱਤੀ। ਸੰਜੇ ਕਿਸ਼ਨ ਕੌਲ ਜੀ ਨੇ ਕਿਹਾ ਪੁਲਿਸ ਵਾਲਿਆਂ ਨੂੰ ਵੀ PIL ਦੀ ਵਿੱਚ ਡਾਇਰੈਕਸ਼ਨ ਦੀ ਲੋੜ ਹੈ। ਮੈਂ ਕਿਹਾ ਤੁਸੀਂ ਆਪ ਹੀ ਸੋਚ ਸਕਦੇ ਹੋ, ਲੇਡੀ ਪੁਲਿਸ ਅਫੀਸਰ ਕਿੰਨੀ ਕੁ ਆਵਾਜ਼ ਆਪਣੇ ਵਾਸਤੇ ਉਠਾ ਸਕਦੇ, ਆਪਣੇ ਹੱਕ ਵਾਸਤੇ। ਤਾਂ ਉਹਨਾਂ ਨੇ 1 ਮਹੀਨੇ ਦੇ ਅੰਦਰ ਅੰਦਰ ਸੈਪਰੇਟ ਟੋਇਲਟ ਬਣਾਉਣ ਦਾ ਆਰਡਰ ਕੀਤਾ ਔਰ ਉਹ ਬਣਿਆ। ਸੋ PIL ਦਾ ਇੰਪੈਕਟ ਤੇ ਪੈਂਦਾ। ਇੱਕ ਕੇਸ ਵਿੱਚ ਮੈਨੂੰ CBI ਕੋਰਟ ਜਾਣਾ ਪਿਆ ਪਟਿਆਲੇ। ਜਦੋਂ ਕੇਸ ਖਤਮ ਹੋਇਆ ਤਾਂ ਜੱਜ ਸਾਹਿਬ ਨੇ ਡਿਸਟ੍ਰਿਕਟ ਜਿਹੜੇ CBI ਦੇ ਕੌਂਸਲ ਸੀ ਉਹਨੂੰ ਪੁੱਛਿਆ ਡੇਟ ਕਿਹੜੀ ਪਾਵਾਂ। ਕਹਿੰਦਾ ਮੈਂ ਡੈਰੀ ਵੇਖ ਕੇ ਦੱਸਦਾ। ਡੈਰੀ ਵੇਖ ਕੇ ਡੇਟ, ਅਗਲਾ ਕੇਸ ਡੈਰੀ ਵੇਖ ਕੇ ਡੇਟ। ਮੈਂ ਉਹਨੂੰ ਪੁੱਛਿਆ ਵੀ ਚੱਕਰ ਕੀ ਹੈ। ਉਹ ਕਹਿੰਦਾ ਸਾਡੇ 4 CBI ਦੇ ਕੋਰਟਾਂ ਨੇ, ਸ਼ਿਮਲਾ, ਅੰਬਾਲਾ, ਪਟਿਆਲਾ, ਚੰਡੀਗੜ੍ਹ, 4 ਹੀ ਕੌਂਸਲ ਨੇ ਔਰ ਚਾਰੋਂ ਕਈ ਵਾਰ ਇੱਕੋ ਕੋਰਟ 'ਚ ਇਕੱਠੇ ਹੋ ਜਾਂਦੇ, ਕੋਈ ਕੋਰਟ ਦੂਸਰੀ ਖਾਲੀ ਰਹਿ ਜਾਂਦੀ। ਕਿਉਂਕਿ ਉਹਨਾਂ ਦੇ ਮੁਤਾਬਕ ਜੇ ਡੇਟਾ ਨਾ ਦੇਈਏ ਤਾਂ ਇਹ ਹੁੰਦਾ, ਕਿਉਂਕਿ CBI ਦੇ ਅਫੀਸਰ ਸੀ ਉਹ ਮਾਰਕ ਕਰਦੇ ਸੀ ਇੱਕ ਕੇਸ, ਕੋਰਟ ਨਹੀਂ ਅਲਾਉਡ ਕੀਤੀ ਸੀ ਕਿਸੇ ਨੇ। ਆਂਦੇ ਮੈਂ PIL ਲਗਾ ਦਿੱਤੀ, ਸੈਪਰੇਟ ਕੌਂਸਲ, ਹਰ ਨੂੰ ਈਅਰ ਮਾਰਕ ਕਰੋ, ਪਰਟੀਕੂਲਰ ਕੋਰਟ ਹਰ ਜਿਹੜਾ ਵੀ CBI ਦਾ ਕੌਂਸਲ। ਉਹ ਸੁਣਵਾਈ 'ਤੇ ਆਈ ਤਾਂ ਆਨਰੇਬਲ ਚੀਫ ਜਸਟਿਸ ਸ਼੍ਰੀ ਡੀ.ਕੇ. ਜੈਨ ਉਹ ਕਹਿੰਦੇ ਮਾਈ ਆਫਿਸਰ ਵਿਲ ਟੈਲ ਮੀ ਫਸਟ, they will not tell you first what problem they are having. And Lordship may inquire from them. Information is sought through the registrar. Ultimately, two of the judges informed that yes, we are facing this problem. Others did not reply. So CBI counsels were allotted courts. ਸਵੇਰੇ ਸਵੇਰੇ ਮੈਂ ਅਖਬਾਰ ਪੜ੍ਹ ਰਿਹਾ ਸੀ। ਮੈਂ ਜੋ ਕਹਿਣਾ ਚਾਹੁੰਦਾ, ਨਵੇਂ ਜਿਹੜੇ ਅੱਗੇ ਆ ਰਹੇ ਨੇ PIL ਦੇ ਵਿੱਚ ਕੰਮ ਕਰਨ ਵਾਸਤੇ, ਇਹ ਤਾਂ ਸਿਰਫ ਸਿਆਣਪ ਦੀ, ਸਿਰਫ ਅਕਲ ਦੀ, ਸਿਰਫ ਅੰਗਰੇਜ਼ੀ ਲਿਖਣ ਦੀ, ਜਾਂ ਸਿਰਫ ਸਾਲ 'ਚ 2 ਸਾਲ 'ਚ ਇੱਕ ਪਟੀਸ਼ਨ ਪਾ ਲੈਣੀ, ਉਹ ਸਫੀਸ਼ੀਐਂਟ ਨਹੀਂ ਹੈਗੀ। ਜਨੂੰਨ ਹੋਣਾ ਚਾਹੀਦਾ ਉਹਦੇ ਮਗਰ। ਸਵੇਰੇ ਮੈਂ 7 ਵਜੇ 6 ਵਜੇ ਅਖਬਾਰ ਪੜ੍ਹਦਾ, ਇੱਕ ਟਰੱਕ ਯੂਨੀਅਨ ਦਾ ਪ੍ਰਧਾਨ, ਉਹਨੂੰ ਇਨਫੋਰਮੇਸ਼ਨ ਕਮਿਸ਼ਨਰ ਤੋਂ ਲਗਾਇਆ ਜਾ ਰਿਹਾ, ਤਾਂ ਸਹੁੰ ਚੁੱਕਣ ਜਾ ਰਿਹਾ। ਖੂਨ ਦਾ ਖੌਲਣਾ ਹੀ ਸੀ। ਪਟੀਸ਼ਨ ਖੁਦ ਟਾਈਪ ਕੀਤੀ, ਉਸ ਵੇਲੇ ਸਟੈਨੋ ਤਾਂ ਮਿਲਦਾ ਨਹੀਂ ਸਵੇਰੇ ਸਵੇਰੇ, ਮੈਂਸ਼ਨ ਕਰਕੇ ਲਗਵਾਈ, ਉਸਨੂੰ ਸਟੇ ਮਿਲਿਆ। ਇਹ ਬਾਅਦ ਦੀ ਗੱਲ ਵੱਖਰੀ ਹੈ। ਇਹ ਉਸਨੇ ਪਾਰਟੀ ਬਦਲੀ ਆਪਣੀ, ਗੁੱਸਾ ਖਾ ਕੇ ਕਿ ਮੈਨੂੰ ਇਨਫੋਰਮੇਸ਼ਨ ਕਮਿਸ਼ਨ ਤੋਂ ਬਣਨ ਤੋਂ ਹਟਾਉਣ ਤੋਂ ਬਚਾਇਆ ਨਹੀਂ। ਗਵਰਨਮੈਂਟ ਬਦਲ ਗਈ, ਨਵੀਂ ਗਵਰਨਮੈਂਟ 'ਚ ਆ ਗਿਆ, ਫਿਰ ਕਮਿਸ਼ਨਰ ਬਣ ਗਏ, ਉਹ ਗੱਲ ਵੱਖਰੀ ਹੈ। ਪਰ ਮੈਂ ਇਹ ਕਹਿਣਾ ਚਾਹੁੰਦਾ ਕਿ ਅਸਰ ਪੈਂਦਾ। ਇੱਕ ਗੱਲ ਮੈਂ ਐਂਡ 'ਤੇ ਤੁਹਾਨੂੰ ਕਹਿਣਾ ਚਾਹਾਂਗਾ ਕਿ ਆਰਗੇਨਾਈਜ਼ਰਸ ਨੇ ਸ਼ਾਇਦ ਦੱਸ ਦਿੱਤਾ ਕਿ ਮੇਰੀ ਇੱਕ ਬੁੱਕ ਹੈ, ਮੈਂ ਆਨਰੇਬਲ ਜੱਜਿਸ ਨੂੰ ਤਾਂ ਚੈਂਬਰਾਂ ਵਿੱਚ ਭਿਜਵਾਈ ਸੀ, ਪਰ ਹੁਣ ਡਰ ਕੇ ਰੀਡਰਾਂ ਦੇ ਥਰੂ ਭਿਜਵਾਈ ਸੀ, ਅੰਦਰ ਜਾਣ ਦੀ ਹਿੰਮਤ ਨਹੀਂ ਸੀ। ਅਤੇ ਜਸਟਿਸ ਸਿਬਲ ਜੀ ਕੋਲ ਤਾਂ ਸ਼ਾਇਦ ਮਿਲੀ ਹੋਏਗੀ ਇਹਨਾਂ ਨੂੰ, ਉਹ ਬੁੱਕ ਮੈਂ ਲੈ ਆਇਆ। ਇਹ ਵੀ ਸੋਚ ਕੇ ਕਿਤੇ ਇਹ ਨਾ ਕਹਿਣ ਕਿ ਬੁੱਕ ਵੰਡੀ ਜਾ ਰਿਹਾ ਔਰ ਸਾਨੂੰ ਪਤਾ ਤੱਕ ਨਹੀਂ ਹੈਗਾ। ਸੋ ਬੁੱਕ ਸੀਗੀ ਪਬਲਿਕ ਇੰਟਰਸਟ ਲਿਟੀਗੇਸ਼ਨ, 5th ਪਿਲਰ ਆਫ ਡੈਮੋਕ੍ਰੇਸੀ। PIL ਦਾ ਜਿਸ ਤਰ੍ਹਾਂ ਅਸੀਂ ਸੰਬੰਧ ਜੋੜਦੇ ਹਾਂ, ਮਿਸਯੂਜ਼ ਆਫ PIL ਦੀ ਗੱਲ ਕਰਦੇ ਹਾਂ, ਪ੍ਰਿਵਿਲੇਜ PIL ਦੀ ਗੱਲ ਕਰਦੇ ਹਾਂ, ਅਸੀਂ ਇਹਨਾਂ ਦਾ ਸੰਬੰਧ ਜੋੜਦੇ ਹਾਂ ਬੈਕਲੌਗ ਆਫ ਕੇਸਿਸ ਦੇ ਨਾਲ। ਮੈਂ ਸਮਝਦਾ ਬੜੀ ਜ਼ਰੂਰਤ ਹੈ ਕਿ ਇੱਕ ਸੈਮੀਨਾਰ ਬੈਕਲੌਗ ਨੂੰ ਕਲੀਅਰ ਕਰਨ ਵਾਸਤੇ ਵੀ ਹੋਣਾ ਚਾਹੀਦਾ। ਔਰ ਮੇਰਾ ਦ੍ਰਿੜ ਮਤ ਹੈ, ਮੇਰੀ ਇੱਕ ਬੁੱਕ, ਉੱਥੇ ਵੀ ਮੈਂ ਇੱਕ ਬੁੱਕ ਲਿਖੀ ਹੈ ਬੈਕਲੌਗ 'ਤੇ, ਆਪਦੇ ਸੁਜੈਸ਼ਨ ਦਿੱਤੇ ਨੇ, ਉਹ ਵੀ ਆਨਰੇਬਲ ਜੱਜਿਸ ਨੂੰ ਚੈਂਬਰਾਂ 'ਚ ਉਸੇ ਤਰ੍ਹਾਂ ਭੇਜੇ ਸੀ ਬਾਹਰੋਂ। ਸੋ ਉਹਦੇ ਵਿੱਚ ਵੀ ਮੈਂ ਕੁਛ ਇਸ਼ੂ ਉਠਾਏ ਨੇ, ਔਰ ਮੈਂ ਬੜੀ ਦ੍ਰਿੜਤਾ ਦੇ ਨਾਲ ਇਨਫੋਰਮੇਸ਼ਨ ਲੈ ਕੇ ਸਾਰੇ ਆਨਰੇਬਲ ਹਾਈ ਕੋਰਟ ਤੋਂ RTI ਦੇ ਤਹਿਤ ਕਿ ਜੋ ਸਾਡੀ ਐਸੋਸੀਏਸ਼ਨ ਹੁੰਦੀ, ਬਾਰ ਐਸੋਸੀਏਸ਼ਨ, ਇਹਨਾਂ ਨਾਲ ਕਦੇ ਵੀ ਫਾਰਮਲ ਮੀਟਿੰਗ ਕਿਤੇ ਵੀ ਨਹੀਂ ਹੋਈ। ਸੋ ਇੱਥੇ ਨਵਾਂ ਇੱਕ ਅਸੀਂ ਆਰੰਭ ਕਰੀਏ ਔਰ ਮੀਟਿੰਗ ਕਰਕੇ, ਸੈਮੀਨਾਰ ਕਰਕੇ ਬੈਕਲੌਗ ਨੂੰ ਕਲੀਅਰ ਕਰਨ ਵਾਸਤੇ ਆਪਣਾ ਕੋਈ ਯੋਗਦਾਨ ਦੇਈਏ। ਅੱਜ ਜੋ ਅਡੋਕ ਜੱਜਿਸ ਦੀ ਬੜੀ ਖਬਰ ਕਿ ਅਪਾਇੰਟ ਹੋਏ ਨੇ, ਹੁਣ ਜਾ ਰਹੇ ਨੇ, ਇਹ ਵੀ ਮੈਂ ਸ਼ਾਇਦ ਇਹ ਅਤਿਸ਼ਯੋਕਤੀ ਹੋਏਗੀ ਜਦੋਂ ਮੈਂ ਕਹਿੰਦਾ ਕਿ ਜਿਹੜੀਆਂ ਰਿਟਾਂ ਲਾਓ ਹੁੰਦੀਆਂ ਉਹ ਤਾਂ ਇੰਪੈਕਟ ਛੱਡਦੀਆਂ ਨੇ, ਜਿਹੜੀਆਂ ਰਿਟਾਂ ਨਹੀਂ ਲਾਓ ਹੁੰਦੀਆਂ ਉਹ ਵੀ ਆਪਣਾ ਅਸਰ ਛੱਡਦੀਆਂ ਨੇ। ਬਟ PIL ਇੱਥੇ ਮੈਂ ਪਾਈ ਸੀਗਾ ਅਡੋਕ ਜੱਜਿਸ ਨੂੰ ਅਪਾਇੰਟ ਕਰਨ ਵਾਸਤੇ। ਸ਼ਾਇਦ ਮੈਂ ਆਪਣਾ ਕਈ ਵਾਰੀ ਦਾਇਰਾ ਕ੍ਰਾਸ ਕਰ ਜਾਂਦਾ ਔਰ ਦੇਖਦਾ ਨਹੀਂ ਕਿ ਮੈਂ ਕੀ ਕਰ ਰਿਹਾ। ਮੇਰੀ ਦਿਲ ਵਿੱਚ ਜਿੰਨੀ ਜੁਡੀਸ਼ਰੀ ਦੇ ਪ੍ਰਤੀ ਸਤਿਕਾਰ ਹੈ, ਉਹ ਮੇਰੀ ਬੁੱਕ ਦੱਸਦੀ ਹੈ ਕਿ ਬੈਕਲੌਗ ਨੂੰ ਕਲੀਅਰ ਕਰਨ ਵਾਸਤੇ ਐਫਰਟਸ ਕਰਨ ਦੀ ਜ਼ਰੂਰਤ ਹੈ। ਇਹਨੂੰ ਮੈਂ ਆਪਣਾ ਵਿਸ਼ਾ ਸਮਝਿਆ, ਆਪਣਾ ਕੰਸਰਨ ਸਮਝਿਆ, ਨਾ ਕਿਸੇ ਦੀ ਜੁਡੀਸ਼ਰੀ। ਸੋ ਇਸ ਟੌਪਿਕ ਦੇ ਉੱਤੇ ਮੇਰੇ ਹਿਸਾਬ ਨਾਲ ਤੁਹਾਨੂੰ ਰਿਕੁਐਸਟ ਕਰਾਂਗਾ, ਬੈਕਲੌਗ ਨੂੰ ਕਲੀਅਰ ਕਰਨ ਵਾਸਤੇ ਕੁਛ ਨਾ ਕੁਛ ਕਰਨਾ ਚਾਹੀਦਾ। ਅਡੋਕ ਜੱਜਿਸ ਬਾਰੇ ਦੱਸ ਰਹੇ ਸੀ, ਮੈਂ ਪਟੀਸ਼ਨ ਪਾਈ ਸੀ ਅਤੇ ਕਿ ਡਾਇਰੈਕਸ਼ਨ ਦਿੱਤੀ ਜਾਵੇ ਆਨਰੇਬਲ ਚੀਫ ਜਸਟਿਸ ਨੂੰ ਕਿ ਉਹ ਰਿਕਮੈਂਡ ਕਰਨ ਇਸ ਟੌਪਿਕ ਦੇ ਉੱਪਰ ਸੁਪਰੀਮ ਕੋਰਟ ਨੂੰ ਕਿ ਅਡੋਕ ਜੱਜਿਸ ਅਪਾਇੰਟ ਕੀਤੇ ਜਾਣ। ਉਹ ਬੜੇ ਉਹਨਾਂ ਸ਼ਾਨਦਾਰ ਸ਼ਬਦਾਂ ਦੇ ਵਿੱਚ, ਉਹ ਤੁਸੀਂ ਪੜ੍ਹ ਸਕਦੇ ਹੋ, ਮੇਰੀ ਵੈਬਸਾਈਟ 'ਤੇ ਮਿਲਦੀਆਂ ਨੇ ਸਾਰੀਆਂ ਪਟੀਸ਼ਨਾਂ ਦੇ ਜਿੰਨੇ ਵੀ ਆਰਡਰ ਹੋਏ ਨੇ। ਜਸਟਿਸ ਸਰਵਨਜੀਤ ਜੀ ਨੇ ਉਸ ਨੂੰ ਡਿਸਪੋਜ਼ ਕੀਤਾ ਸੀ। ਮੇਰਾ ਕਹਿਣ ਦਾ ਭਾਵ ਇਹ ਹੈ ਕਿ ਅਸੀਂ ਬੈਕਲੌਗ ਬਾਰੇ ਕੁਝ ਕਰੀਏ। ਥੈਂਕ ਯੂ।
So we had thought we'll do the distribution in the interactive session today. Sir had graciously got a few copies for us. So Sir had said, "Okay, Satyam, we'll distribute them today." So we thank you, sir. Thank you for your valuable insights. I think all of us have really resonated with your experiences. And now, sir, I would like to request our chair for today, Honorable Justice Deepak Sibal, sir. He shall be taking us through the landmark cases that showcase the power and the impact of PILs And over to you, sir, now.
Good evening, all of you. A few days ago, Mr. Tandon came to my chamber and he says there's a talk being organized by members of the bar on public interest litigation. Would you be a part of it? I said a talk being organized by members of the bar. Ab theek hai? A talk being organized by the members of the bar and a youngster coming forward to make that request. Where is the question of saying no? There is no question of saying no. I'd love to be part of it. You see, I hope and I'm sure you realize it, you youngsters here, there's a lot of responsibility on your shoulders. There is no tomorrow without you here in the bar. You are the tomorrow. And without a responsible bar, as our bar is, there is no wheel of justice which will move. Okay, I don't know if I've shared with you here or the court sometime. I will. I spent about 25 years here in the bar as a lawyer, as a senior counsel. And this is my 11th year of judgeship. Spent about over 35 years in this institution. This institution has given me a lot. Whatever I am here today, it's with the blessings of the Almighty, my parents, and whatever this institution has given me. After 35 years now, after about 5 years, I'll retire. No issues. The day you assume office, your date of retirement is retirement. But believe me, there is one thorn which actually pricks you at retirement. I thought this was the forum, let me just speak to you. This is extempore, I just wanted to share my heart with you as I always do. At the time of retirement, the thorn that actually pricks somebody like me is that after I retire, I may not ever come back into this institute. I actually may not ever come back here. The young lawyer, and there's a lady who came to receive me. She says, there she is. She says, let's walk from here through the corridor. I went, no, let's walk through the corridor of the bar. Because walking through these corridors actually brings back these emotions. And as I walked down, I just felt like just talking to you like this. So just understand, enjoy the time you are here, nurture the bar, enjoy your time here, but with responsibility. And this is where I will end also on the topic. As I said, on the topic, 4 eminent speakers have already spoken. And you see, if the speakers are not good, then the person who speaks last and who is well prepared leaves with a bang. But if the speakers are good and if you are the last speaker, then you are left like me. Nonetheless, I prepared a note, so you better hear me. Now you bear with me, like normally we bear with you. On PIL, you see, normal litigation, traditional litigation is A litigant versus B litigant. They fight their case on fact and law, the judge decides. But public interest litigation was a significant departure from traditional judicial proceedings. It was rather a revolution in the judicial process. Here the public was directly connected with the judiciary without the public being before the court. And it was through an organization, persons like Mr. Arora, public-spirited persons, NGOs, and the best of all, without there being a litigant, when the court suo moto issues notice on an issue of public importance. So this was actually a revolution. And this has been, this phrase has been used, this is the third time being used, I had written it here, so I'm showing I had written this phrase too. This was voice of the voiceless. This was actually for the voice of the voiceless. It was a collaborative litigation. It was not adversarial. The petitioner, the court, and the state would get together to solve an issue of public importance. There was nothing adversarial about it. This was the difference in the litigation or the common litigation, because every time you would say you're fighting a case. But this was a case which you don't fight, you resolve. And this was what you resolve is the issues of fundamental rights of the masses, the oppressed masses, the bewildered masses, and many of whom who can't even afford to go to the court, many of whom who don't even know what the law is, whether they have this X right or Y right, they don't know. So it was their cause that had to be espoused, rather brought to the notice of the court, and then resolved through Mr. Arora, the court, and the state together. Slowly and steadily, this became one of the most emulated features of the Indian judiciary. And today, so it is. PILs actually are a very important tool, especially in a democracy. They ensure that fundamental rights are safeguarded of the masses. Human rights, corruption, as Mr. Arora highlighted, and the government is held accountable wherever they are found lacking. But again, the object is the masses, not ABC. The seed was sown in 1976 by Justice Iyer in Mumbai Kamgar Sabha versus Abdul Bhai. But in that judgment, His Lordship didn't use the phrase public interest litigation. And he used it for the first time in Fertilizer Corporation Kamgar Union versus Union of India. And between that day and today, this phrase has actually transformed the Indian judiciary from a committed judiciary to a committed and active judiciary. This judicial activism actually, believe it or not, was triggered by PILs. So therefore, from committed, today the judiciary is committed and active. Advantages and disadvantages, yes, both were highlighted by the speakers before this. Now, I was told to just highlight the advantages and the disadvantages. I'll try to do so. One of the most significant advantages of PIL is that it provides access to justice for the marginalized, as I just said. Traditional litigation is often expensive and time-consuming, making it difficult for the poor to seek legal remedies. PIL allows social activists, non-governmental organizations, and concerned citizens to file cases on behalf of those who lack the resources or the knowledge to do so. Now, the first judgment which comes to mind on bonded labor is the People's Union for Democratic Rights versus Union of India in 82 by the Supreme Court. Here, the entire labor laws were reconsidered and several changes were then suggested by the Supreme Court in this judgment, bringing about great social change. Then is Vishaka. The government was lacking, although I would say the legislature was lacking. There was no law. if there was any sexual harassment to a lady in a place of work. So the Supreme Court then steps in a PIL and not just lays down guidelines, but also issues directions to the legislature to take legislative action as soon as possible. Fortunately, things are moving in the right direction. Now, recent two judgments, 2024 and 2025. 2024 judgment of the Supreme Court is Rajiv Raturi versus Union of India, which reshaped the landscape of accessibility rights for persons with disabilities in India. One of the major difficulties faced in enforcing the accessible mandate and making accessible a real right under the 2016 Act was then got enforced by the Supreme Court through this judgment. And now the Supreme Court through this judgment has made accessible travel for the visually impaired in public transport and directed the state to make necessary infrastructural changes. Now in 2025 recently, there is a judgment of the Supreme Court in Rajiv Kalita, which affects our courts, the sanitation in our courts. And this judgment was in a PIL under Article 32 of the Indian Constitution filed before the Supreme Court. And the issue raised was with regard to hygienic toilets in court premises. We are very fortunate that we have reasonably good toilets here. I hope they are. If they are not, please let me know. I'll do my best to
Renovating also.
Yes, we are renovating. Yes, we are renovating the toilets also, all of them, in fact. So, but you see, other courts, especially the district courts in several rural areas of our country, were not that fortunate. They were in a bad shape. So those issues were then taken up by the Supreme Court, and in 2025 they've decided and issued directions. In fact, a committee is being formed in every court, in every high court, to supervise that all districts have hygienic toilets, and not just for men and women separately, but even for transgenders and physically handicapped persons. So that is something which the Supreme Court in 2025 has, I would say, much needed directions which have been issued. Then, of course, the old cases of all of you, I'm sure, are aware of Olga Telles, and I made a note, so I'm just reading them out. So this is Olga Telles and the Nalsa Union of India landmark case, again, recognizing the rights of transgenders. Again, a 2014 judgment by the Supreme Court. Environment issues, who better than Mr. M.C. Mehta, series of judgments by him, in cases filed by him, and Godavarman again on environment issues. So that, well, I had noted them, so I thought I must go through them. So whereas the PILs in this court are concerned, I purposely kept away from them because I knew Mr. Arora is coming. So actually, Mr. Arora, therefore I just stayed away, and I thought it will be a repetition if I refer to those cases. Before I go to the cons, there is one thing, of course, we all went through the dreadful COVID pandemic. Here again, PILs came to the rescue. For the migrant laborers, PILs were filed. For food distribution, healthcare facilities, wherever oxygen was not available, PILs were filed and lives were saved. So these are the roughly the pluses of a PIL. And of course, Mr. Kang highlighted and Mr. Verma that frivolous PILs are also filed, no doubt about it. Like several acts which come with a great laudable object, but people tend to misuse them. And here too, this was introduced by the Supreme Court in '76, developed over the years, but people tend to misuse them. And then the P in the PIL becomes private interest and political interest and publicity interest. But that again, I come to point one. And as Mr. Kang said, that is, you see, we can make the rules. We have made those rules under the directions of the Supreme Court in 2010. It's been 15 years now, over 14 years. And we try to do our due diligence, checks and balances are put so that frivolous cases don't come. The reason is there. You see, we are already overburdened. As again Mr. Arora highlighted, it's a fact. We are overburdened, no doubt about it. To have frivolous cases again filing and piling before us by people who are not even aggrieved technically and are abusing the process of law, that would again, of course, not be desirable. So therefore, we put the checks and balances and try to deter them. But ultimately, it's you, as all of you said. Ultimately, it is you and your conscience. It is you who has to see when a case comes to you. And as Mr. Arora says, जुनून चाहिए. अगर जुनून है पब्लिक स्पिरिट का, फिर तो क्या बात है? वो चाहिए. Nothing, और कुछ नहीं. And that Karwa Chauth was actually, I don't know. I really don't understand. And when he was saying, let me read, I told Mr. Janji, it must be that Karwa Chauth. This was actually the pits. Actually, I mean, chalo, it's all right. It's over now. So it's a judicial order. It's over. I'm glad it's over. So all I can say is the future, the youngsters here. It is for you to ponder, to think. Whenever you accept a brief, should I not?
There is a PIL manner that the women lawyer, they need maternity benefits before the teachers.
No comments. With sub judice, so no comments. I'm sure.
We are not governed under service route, but notice was issued. Sometimes
Sub judice matter, it's better. I'm sure the bench will appropriately deal with it. I'm sure. So all I'm saying is this: just I am sure. I mean, we have touched wood. We are a very responsible bar, and बस थोड़ा जागते रहो.
Yesterday also Kumbh Mela PIL also filed.
Well, these are complex issues actually. These are complex issues, not easy to comment on, and should not.
PIL about dog menus, it's also underway.
As I said, once it is sub judice, no, there are lovely issues. I'm saying there are wonderful issues being taken up through PILs, but all I'm saying is these frivolous ones, the vexatious and the other issues, let your conscience decide, right? So I wish you all the best. Thank you, Mr. Tandon, and thank you all the organizers for inviting me and giving this opportunity to me to again visit the bar, which I love. And thank you very much.
Thank you.
Jai Hind.
Thank you, sir. Thank you so much for your distinguished and difference-making speech, I would say. And like sir has asked already, and now I would like to open the floor up to everybody. Imran, I see, is here. So I think predominantly all of us are talkers. So for so much time, listening is also sometimes difficult. So it's very important to have an interactive session.
Listening for 40 minutes is difficult for you. We listen from 10 to 4.
Very good evening. My primary question would be twofold. A, I was always told that a lawyer's job is first only to defend, not to judge. In terms of that, conscious of the fact that we're officers of the court, conscious of the fact that the degree of triviality will differ from person to person. A, would it be appropriate as a counsel to judge your own client before furthering their interest in court? B, in light of the recent Delhi High Court judgment which said that counsels should refrain from becoming litigants themselves, what would the panelists have? Should we actually refrain in matters that even affect us? Should we only further interests of our clients? Just a two-fold question.
Well, so far as the issue being a litigant is concerned, if you are personally and if you feel that it affects public at large and nobody is bringing forth, there is no harm of becoming a litigant yourself, being a lawyer also. So that you would be doing justice to public at large again. So therefore there is no harm being a lawyer, you can't be a litigant. So far as being an issue is concerned, Again, that issue has to be seen by you, whether in what aspect is it touching the public at large. If it is not, then of course you can't coin it as a public interest litigation, but you can coin it as a writ petition or any other appeal for the purpose of redressal of a grievance. So that is how you need to distinguish it. That is what I feel.
And Honorable Judge already answered your question while he was speaking. His message was, let your conscience decide. Don't judge your client. Let your conscience decide whether you want to take up the brief or not.
And keep it clean.
Keep it clean.
Request anyone, any other questions? Yes, sir.
Like Mr. Ganji and Mr. Arora said, the issue has to be regarding the public in question, which affects the public. My question to the Lordship would be, if an PIL comes up before you, what weighs on the mind of the bench that this is just a public policy not to be interfered, or yes, this thing has to be taken up by this court and something has to be done about this issue?
It all depends on the facts of the case, actually. It all depends. And incidentally, I've never been on a PIL bench. Number one, that's the disclaimer. In these 11 years, I have sat in the first bench for 6 months, but at that time, the PIL roster was with bench 2. So, so I've never sat. But generally, just answering your question, it's all fact. It depends on the facts of the case. No hard and fast rule can be actually laid down here. We hear a matter, we hear the facts within the four corners of the law. If we find there's merit, we proceed further. If we find there's no merit, we finish it there and then. It all depends on the facts of the case.
Thanks.
My question would be similar to Imran's question. If someone comes to you for a PIL and it smells of certain malafide, not particularly too harsh, but some prejudice, maybe a political agenda, but the underlying issue I can see that would affect the public interest at large as well, whether it would be correct to go through with it with that person who came with me with the idea, or whether should I differentiate from him and file on my own accord, whether that would be correct. What would be the way to proceed if there is maybe, let's say, some councillor comes from a city without naming anyone and some project is going on over there. I can see that he has some political agenda with the other councillors as well. Whether it would be right to proceed with his idea, with the keeping in mind the benefit of the public at large.
That person can't be your client, because that rule says so, that if you have to disclose your personal interest as per our 2010 rules. If he has a personal interest, then for him it can't be a PIL. So on his behalf, you certainly can't file a PIL. He can file as a personal litigant, he can file as a petitioner, saying that I am grieved, I am a councillor. He can file, I am a councillor, I have seen this happening within my municipal limits. I feel this is illegal, so please stop it. And I have tried to do my best as a councillor, but nothing is happening, therefore I have come to the court. As a personal, but as a PIL, no. As a personal litigant, yes, you can file on his behalf.
Any other questions? Anybody? Shall we?
We have space for one more and nobody else. Do we feel that the media, because a lot of times, like the 2G spectrum scam came up because of the media, the Nirbhaya rape case also got publicized a lot because of the media's involvement. What do we feel is the impact of the media on these PILs? Do they have a bearing on the court's mind while deciding it? Because primarily media, I mean, we have seen over the years that there has been a selective degeneration in the quality of content that comes forward. However, that gives a different public perception to the public at large. So is there an impact of these media channels and the media in totality over these public interest litigations?
Asking me?
Anybody.
Well, firstly, I am not commenting on the quality of media going up and down. No comments. I have no knowledge of that. But well, these things don't affect you at all. Whatever is in the brief, whatever is argued before you, whatever the evidence is placed before you, you actually examine that and pass an order. These things actually don't bother you at all, because I mean, it's dangerous to rely on media reports or media any newspaper report or anything. It's dangerous because we go by evidence, and that's it. Thank you very much. And all. Okay.
So we'd like to formally conclude today's session. Sorry. Yes, we will be distributing Arora sir's books after this. I request everybody to come forward and take a copy. Now I'd like to request Saksham, he's a member of the Vidhi Talks team, to conclude today's session by delivering the vote of thanks.
Good evening, my senior members of the bar, my brother, sister, colleague, which have given their valuable time. Thank you, Honorable Mr. Justice Deepak Sibal sir, Amit Jhanji, Senior Advocate sir, Amit Thind, Secretary, High Court Legal Services Committee, Shekhar Verma sir, H.C. Arora sir, Kamalbir Singh Khan sir, for your time and valuable insights. I would also express my gratitude towards Suvir Sidhuji, Member Bar Council of India, in reposing their confidence in me that I can organize such events. However, my mother does not think so that I can. On a lighter note, everyone is please requested to watch all the videos on YouTube. It is a channel of Bar Council, and Vidhi Talks is there. And please everybody stay for a cup of coffee and a bright photo with Mr. Smith. Please.
Okay. You want to present?